Whether it is education reforms or the rent legislation or the anti-terrorism legislation, government is backtracking. Right? Whether that is admitted, it's obvious that it is backtracking. Now, grade 6 is not being implemented now this year. Right? Because it is flawed. No other reason. So these are legislation is serious business. Huh? You don't do it willy-nilly. This is not the first government that is doing it. But it is a question of frequency with which it is happening. Legislation that is being introduced is not properly thought out. Look at the title itself. The purpose seems to be to protect the state. Right? Protection of the state. You must entertain suggestions of the public before drafting the legislation. Not putting forward a flawed, unsatisfactory draft. Right? Listen, I can assure you that nobody is going to build a house and give it to a tenant. To a tenant, I mean, people who have houses will prefer to keep those houses locked up rather than give it out to a tenant, because you may not get those premises back at all.
Welcome to the Insight. I'm Shiharanis. Today we have in studio an eminent personality who is popular for his comments on governance as well as his academic achievement in law as well as foreign policy. Today we have none other than Professor G.L Pieris, former Minister of Foreign Affairs, former Minister of Law and International Trade. Welcome to the show.
Thank you,
Professor. Let's ask about the legislation now, Professor. I think you have been in politics since 1994.
Yes.
And you were the foreign minister at one point. You were the Minister of Judiciary and then International Trade until I think 2015. How do you see things now?
Well, I think they are in a somewhat uncertain state, and there are real problems about some legislative initiatives. Legislation that is being introduced is not properly thought out. Now, let's take the anti-terrorism legislation, for instance.
You mean PSTA?
Yeah.
Okay.
PSTA, quite apart from politics, that is one of the most dangerous pieces of legislation which have been proposed in this country for several decades. Look at the title itself. The purpose seems to be to protect the state, right? Protection of the state. But the purpose of such legislation should be to protect the public, not the state, right? So even the title gives cause for concern about the purpose and object of the legislation. And look at the content of it. You know, in any society, you need extraordinary legislation to meet extraordinary situations. Because the whole history of human civilization is about finding a proper balance between security and freedom. But that balance is not struck by this legislation at all, because the basic problem is that terrorist offenses are not properly defined. So almost anything can be given a coloring and brought within the purview of the definition of terrorist offenses. You know, there are 13 major categories of terrorist offenses that are recognized in the law. You know, connected with terrorism directly or indirectly. There must be precise definition. That is the first thing. If you don't have a precise definition, then there are very serious problems, because when it comes to enforcement, there are huge, very extensive powers given to the armed forces, the police, the Coast Guard personnel and so on. They can walk into your home at any time. if you are suspected of a terrorist offense, and a terrorist offense is not properly defined. So they can come into your home, interrogate you, seize your private papers, right? They can stop you on the public highway, search you. All that is possible. And take detention orders. There is provision for detention orders. Now, unfortunately, Sri Lanka is a country which has a very sad history of extrajudicial killings and torture, right? So much of this has happened not in judicial custody, not in the ordinary prisons even, but in specially designated places of detention, special places. Now, that's possible under this law.
Which was not there in the previous law.
No, it was there in the 1979 legislation also, it was there, but then the whole agitation was that that law should be changed. In some ways, this is worse than that, right? For instance, in the 1979 legislation, you didn't have a direct provision about proscription orders. Here there is a direct provision. So in that way, it is worse than the law that it is supposed to replace. Under the present law, the president has the power by mere notification in the government gazette to describe a place, to designate a place as a possible, So then you can't enter now as a journalist. You can't prohibit it. Let's take the provisions about prohibited places, right? The president can designate a place as a prohibited place. You can't enter that place. If you do, 3 years imprisonment, right? You can't take photographs, no video recordings, no notes, nothing. So the people who are worst affected by that are media personnel, journalists, right? So that is a prohibited place. Then proscription orders. Any organization can be proscribed.
Without any reason?
No, it's a mere gazette.
Okay.
And what is more, the proscription order will remain in force until it is rescinded by the president. No time limit. Now that also in that direct form did not have a place in the 1979 legislation. So in some ways, this is going back. It is not going forward. Right? It is regressive. So these are very dangerous features of this law, and that is why there has been such a strong public reaction. University professors, Buddhist clergy, the Catholic Church, civil society organizations, right? The Center for Policy Alternatives, all these people have pointed out how dangerous this legislation would be. Restriction orders can be issued in such a way as to prevent people from engaging in their profession, association, movement. In short, if you ask me to sum up why this legislation is so dangerous to the democratic way of life, I would say it challenges, it threatens things that we have taken for granted in our society. The freedom of expression, you're doing it all the time, you're commenting on public issues, freedom of assembly, association, right? To belong to any organization that you think is in line with your beliefs and interests, right? Now, all of this is no longer possible once this law is enacted, and the basic problem with it is a sense of fear that is instilled in the public. You cannot live your life and as a citizen fully participate in the affairs of your community without inhibition, without duress, right? That is not healthy. That is the collapse of democratic values which we have been accustomed to for many years, right? And it's something that we consider sacred and cherished in our culture. Now, this law is incompatible with all of that, and that is why it's absolutely important to modify this drastically. Of course, the Minister of Justice has in a way conceded that this appeared on the Ministry of Justice website towards the end of December. But he did say, the minister said that he will not take any steps to enact this legislation until the end of February. So he was giving time for the public to criticize a lot, to make suggestions. And he said that all those suggestions will be taken into account before presenting the final versions. Also, that is a concession that this law needs to be changed. That it will not be enacted in the form in which it has been presented. Right? So we appreciate that that spirit of flexibility and openness. But certainly, very drastic, very fundamental, not cosmetic, very fundamental changes will have to be made before that bill finds itself into the statute books of this country.
Professor, you were involved in this the lawmaking for a long time. Now, the PTA, this 1979 legislation, has been described as a draconian law. Since 1994, what were the discussions took place on changing this, and how did you all basically come up with a new law? I think there had been time to time they were trying to change this, but nothing has happened so far.
No, it was, by the time I became foreign minister in President Gotabaya Rajapaksa's government, right? It was very clear that law had to be changed. So what we did was I went to Parliament and presented some changes which were immediately necessary. You see, that was not everything that we were proposing to do. We were going to start there. The most urgent changes. So I told Parliament, this is a beginning. And I got those changes made. The law was amended. The most obnoxious, right? The most dangerous features of the law were taken out, right? But we were proposing a complete overhaul of that legislation. Not ad hoc amendments, but a complete repeal of that legislation to be replaced by new legislation.
So it's ATA. Are you referring to ATA?
No. After that, in President Gotabaya Rajapaksa's government, we appointed a committee consisting of the Attorney General's representative, right? The Armed Forces, the Ministry of Defense, the Ministry of Justice, the Ministry of Foreign Affairs, all these institutions were represented. And a lot of very valuable work was done. So we were going to replace, not amend, replace the legislation. Then what is more, I went to the Human Rights Council in Geneva and gave a solemn undertaking as Foreign Minister of Sri Lanka that the PTA will not be applied until the new legislation is in force. So that's called a moratorium. We said that we will have a moratorium. This law is not going to be used. So that is there on record in Geneva. And the Inspector General of Police issued instructions accordingly. Unfortunately, it was not adhered to by subsequent administration. So we're going to change this fundamentally. So now we have a new proposal. But their proposal is worse than the last one. Right? So that is not helpful at all. So there are basic deficiencies in the content of it, in the drafting of it, right? And so what we need to do is to take advantage of the opportunity that the Justice Minister has given the public, or all of us, to make constructive suggestions. And we do hope that these suggestions will be taken into account and the law amended accordingly.
Professor, usually when you go for a change or new law, you discuss in length and you discuss with the stakeholders for a long time, take note of their concerns. Did that consultation process take place in this legislation?
No, that is the problem. Not only in the case of this legislation, but a lot of the legislation that is being introduced by the present government has not been drafted after proper consultation with stakeholders. The Prevention of Terrorism Act is not the only example. Now take, for example, this tenants bill. There is now a bill to repeal the Rent Act, number 7 of 1972, and there is another proposed law to give protection to occupants of premises. Right? Now, it is very clear that this legislation has not been prepared after taking into account the problems of landlords, the problems of tenants. In other words, there has not been a sufficient input. Now, I'll give you an example. See, the Rent Act of 1972 gave protection to tenants. You could not be evicted. You couldn't be thrown out of those premises except for very specific reasons. The rent was controlled. Key money, things like that were prohibited. So the tenant was protected. But that is so long as the tenant was paying his rent and complying with his obligations. Now what is proposed? It is proposed to protect anybody who has been in possession, lawful possession, for 3 months. Okay? So I put you into possession of my house as a tenant. You occupy that for 3 months. After that, you stop paying rent. And you use the premises for some, let's say, for some other purpose. Okay? Now, the law says that I can't evict you. The only way that you can be evicted is by an order of court. So, we all know how time-consuming that process is. So, the tenancy agreement would have come to an end, or it has been violated. But the landlord is entirely powerless. He has to continue paying the electricity charges, water charges, sewage, all of that. He's out of pocket. He has to spend all that. He's not getting any rent. And he can't get the premises back. So is that fair? Will anyone invest in housing? Now let's say you have borrowed money from the bank. Let's say you have borrowed 20 million rupees. Okay? Now you are wondering how to invest this. There are many options. No, you don't necessarily have to build a house. You can buy land. There is a considerable appreciation of land values today. Or you can invest in the share market. Or you can put the money in deposit in a bank and take the interest. Right? Now, who in their senses is going to invest in housing knowing full well that you are left without any protection against a tenant who is violating all the conditions of the tenancy agreement and who is remaining in occupation? There is nothing you can do about it. Then what is the bank going to do? Now, the bank has lent you the money. And this house, the property has been pledged as collateral, right? So now the landlord has no income. He's not getting any income. So he can't pay back the loan. Now, can the bank seize that property and sell it? You can't, because there's no vacant possession. Who will buy a house which is already occupied? What are you going to do? You can't live in it. You can't give it out, right? Then, so the bank is also without any remedy. Who suffers? The public. That money does not belong to the chairman and the directors of the bank. It belongs to you and me. We have invested in the bank. We have put our money there. So all of these repercussions flow from this piece of legislation, which is so ill-conceived. Why? Because of inadequate consultation. You can't make laws like that sitting in a room and putting on paper whatever comes into your head. You have to talk to people. You have to inform yourself. No, that is not happening. It is not happening. I mean, all governments make mistakes. But the problem here is a U-turn. Every so many pieces of legislation, the government tries to do it, then encounters opposition, and the opposition is reasonable opposition. Right? Then it does a U-turn. It turns back. That is not good, because that destroys faith in the legislative process. It has happened in the case of the anti-terrorism legislation. It's happening in the case of the rent legislation, because government has said they are not proceeding immediately to enact it. They are now entertaining suggestions of public. But you must entertain suggestions of public before drafting the legislation, not putting forward the flawed, unsatisfactory draft. Right? Then take the education reforms. Now, highly emotive on both sides, but what has actually happened is the government has said that the grade 6 reforms are being postponed. Grade 6 reform to postpone for 1 year. Why? Because there was something wrong. Otherwise, why do you postpone? So then that again is because it was not properly thought out before the attempt was made to implement it. So whether it is education reforms or the rent legislation or the anti-terrorism legislation, government is backtracking. Right? Whether that is admitted, it's obvious that it is backtracking. Now, grade 6 is not being implemented now this year. Right? Because it is flawed. No other reason. So these are legislation is serious business. You don't do it willy-nilly. You do it after proper reflection. Then the government has support from the Attorney General's Department, the Legal Draftsman's Department. So you have to consult your officials. You have to take them seriously. Right? You can't just brush aside the input of competent officials. And most of all, you must talk to the stakeholders.
You spoke about three legislation, Professor. Anti-terrorism legislation, education reform, and then the tenant rent bill. I mean, these three are just, a few of they have the past so far. Why do you see this kind of lacking coming in this legislation? Or do you see kind of an incompetency in this process?
No, I don't want to use epithets like that. But if it is going wrong in so many different instances, not one, then there's a systemic flaw. Right? It is not confined to one particular instance. So I think the reason for that is how this legislation appears to be drafted in a kind of cloistered environment. But when a government is in power, it can't work only with its cadres. There has to be a broader spectrum. Right? So you have to consult with those segments of society that are going to be affected by the proposed law. Now it is happening, you're putting the cart before the horse. Before the consultation, you are presenting laws. Then when it becomes perfectly obvious that the law is fundamentally defective, then you do a U-turn. That's not the way to make laws. Right? So the answer to your question is greater openness, greater receptivity to constructive suggestions about the content of the proposed law, and it must be done in a spirit of humility. Nobody knows everything. Right? There have been Dr. Colvin de Silva was Minister of Constitutional Affairs, but he took advice. Mr. Ronnie Devell, who probably was Sri Lanka's most effective finance minister up to now, always took advice. Right? When I was in the Treasury in President Kumaratunga's government, she was the Minister of Finance, I was a deputy. I presented 7 budgets in a row, 7. The only person who has presented more than that is Mr. Ronnie Devell, who presented 9, but 7. But I always took advice from officials. Right? So that is necessary. You have to approach this in that spirit. Consult with your officials, consult with the public. What are committees of parliament for? You have select committees, you have consultative committees. That is in order to receive different points of view. Of course, the elected government has a mandate. At the end of the day, on policy questions, the government can decide what it wants to do. But it must be informed. It must be fully informed. It must know these are different options. And if you do it this way, these are the consequences. Now, the rent legislation, I can assure you that nobody is going to build a house and give it to a tenant. I mean, people who have houses will prefer to keep those houses locked up rather than give it out to a tenant, because you may not get those premises back at all. So those are obvious. It doesn't require a great deal of learning or erudition to figure out that is the consequence of the law. It's obvious on the face of the legislation, right? So the fact that legislation like that is presented, put on websites and so on, shows that there is something wrong about the basic method of preparation of laws.
Professor, have you seen, in your experience since 1994, have you seen this kind of U-turns in legislative process.
So, yes, I mean, it's not fair to say that it has not happened in the past. Of course, it has happened in the past. It's not the first government that is doing it. But it is a question of the frequency with which it is happening. Yeah. I mean, this government has been in power for about a year and 3 months. So how many times has it happened? It's not unique. It is not unprecedented. I'm not saying that it is. Right? We have to be fair in these matters. But it is happening too often, and it is destroying confidence in the legislative process. That is not a good thing.
Okay. Let's come to the foreign policy of this government or in the Sri Lanka. We have been always saying that we are a non-aligned, we are maintaining a non-aligned foreign policy. Does it actually matter now? Non-aligned foreign policy.
Yeah, but are we really non-aligned?
Exactly.
Now, if you look at the newspapers today, the situation in Gaza, right? I mean, so many countries have condemned that situation, the manner in which Israel is behaving there. How many thousands of women and children have been killed? But Sri Lanka does not raise its voice against it. Many other countries are doing it. Many Western countries are doing it. European countries are doing it. But we are not doing it. Right? So are we really non-aligned? And I think that is very much against the prevailing sentiment in Sri Lanka. And it's not just the Muslims, but across the board, there is very strong feeling. But I mean, look at those images, horrifying. In the thick of winter, floods, water, little children exposed to the elements, children being bombarded, dying, hospitals being bombed, bleeding children, so we don't even, Sri Lanka, that's the headline in one of the newspapers today. So foreign policy is not all about morality. Foreign policy is enlightened self-interest. One of England's most famous foreign ministers, Viscount Palmerston, said, Her Majesty's government has no friends, it has only interests. Right? So your interests change from time to time. Your enemy yesterday becomes your friend today. A country against which you have said all the possible negative things may be today your best friend. These things change from time to time. But I mean, there must be a certain core, a certain substratum of belief in right and wrong. So it is difficult to look at all the things that are happening in Gaza and say, we won't say anything. We remain silent. So whether we are non-aligned is highly questionable. So foreign policy, to be credible, must be justifiable. It must have some degree of consonance with the prevailing mood of the public in that country. Of course, the whole world is changing. With President Donald Trump, nothing can be taken for granted. That is because it is no longer rules-based. You see, it all depends on
trade,
personal reactions and so on. But the United States played a key role in establishing these organizations and introducing a rules-based international order. Rules-based. The World Trade Organization. The Human Rights Commission, right? The World WHO, WTO, all. Then these institutions with regard to climate change, global warming, all of it. Right? That's all being reversed. Not tweaking here and there. Obviously, you have to make changes with time, but this is turning the whole system upside down. Right? So then the question is, now what is the role of the United Nations? Secretary General says, there's very little we can do. We have no money, we have no influence. Right? So that is a sad situation. Then might is right. But why were these institutions established? The United Nations organization, the Bretton Woods institutions, right? You have the Charter the United Nations Charter, all of that. So how much are those documents worth today at all in practice? So there's a lot of cynicism around, a great deal of cynicism. So in that situation, Sri Lanka is not a major player on the global stage. But we mustn't underestimate our assets also, like geographical location in the Indian Ocean, with all the sea lanes from the Far East to the Gulf and to Western Europe. So we have all that. And we have had the benefit of an open economy since 1977. Long before the government of Narasimha Rao in India and Dr. Manmohan Singh, who was governor of the Reserve Bank of India and then became finance minister in Narasimha Rao's government. But Sri Lanka had introduced open economy before India. Then we have our human resources. Don't forget that. If you ask me what is our abiding asset, our most important asset is the caliber of our human resources, right? So that's why we need to improve our education systems, bearing in mind the nexus between education and livelihoods. We have all those things. Now technology is being introduced, artificial intelligence and so on. So we are not impoverished in that sense, but we must make sure that we make the maximum use of our natural advantages.
Moon Lanka. Since 1995.
The foreign policy is very crucial, Professor, now. If you take the way things are going geopolitically in Sri Lanka, especially with India vis-a-vis China. How did you navigate that when you were the foreign minister?
Oh, that is a challenge, no doubt, right? But the first thing is that to handle it with any degree of effectiveness, you can't do it in an ad hoc way, see, reacting to situations. You must have a set of principles, right? Now we had a situation where, there was an application for a ship to come into our waters. So Sri Lanka first allowed it. Then
you are referring to Chinese researchers.
Yeah.
Yes.
Then there were some developments that took place, and then Sri Lanka said, no, we withdraw permission. Don't come. By that time, the ship had left the Chinese port. It was on its way. It was somewhere near Indonesia. So we gave permission, we withdrew permission. And then when there was a reaction to that, we withdrew the withdrawal. And we said, okay, come. I don't think that's the way to handle foreign policy. First you say yes, then you say no, and then you say yes again. In the process, you antagonize everybody. So it means that there is no coherent policy or set of principles that you are trying to give effect to. All ad hoc. All depends on how much pressure there is. Who is exerting the greater pressure at any given moment of time? So then foreign policy becomes, who would respect a foreign policy that is made like that? So I think you have to think through it. Now, what is our policy? What categories of ships would we admit, right? And what would we permit them to do in Sri Lanka's territorial waters? What are the other conditions? Should they be affiliated to any organization in this country? What is the period for which we would allow them to come? So these are matters about which you must have some definite principles, and you apply those to anybody across the board. You don't have one rule for one country and another rule for another country, because it doesn't work. So I think those are some lessons to be learned from some of the experiences that we have been through.
Coming back to politics, current situation, Professor, how do you see things moving at the moment, right? We have seen a drastic change from the previous governments to this government.
Okay.
Right? How do you see things moving?
Well, there was a very high level of expectation. That is because people were told the past 76 years have been a complete waste of time. Corruption, pillage, plunder. Right? So now it's time for a completely new change. Start all over again. Sweep all this away into the dustbin of history. Start all over again. Huh? Now, in the first place, that is a flawed premise. 76 years, imagine in 1948, okay, what was the life expectancy? What is life expectancy today? For men, it was in 1948, it was in the 50s, about 55, 56. Huh? Today, it is about 85. It's a little more for women. Huh? So, surely, I mean, there's been change. Why? Because of the quality of the health system. What is the literacy rate? In 1948, what is literacy rate today? How many central schools were there in 1948? Was it possible for a rural child, an intelligent child, to go to the university and go ahead in life? Social mobility, was it possible? Huh? Take electricity. How many rural homes had electricity in 1948? How many have today? So that whole premise is flawed to say that nothing happened in 76. There's a lot of things happened. Good things, progressive things. Of course, there were negatives. In which country can you say for 7 decades there were no negatives? Right? There were. Now, when you say all of that is going to be swept aside, then expectations are at a very, very high level. Now, what is happening today is a public disillusion because of the gap between the aspiration and the delivery. That is because of overpromising. When you overpromise, there is always a danger of disillusionment. So that is now happening, right? With regard to the cost of living, the availability of medicines, the education sector, right? Food prices, inflation, then other problems that are rising from day to day. So that is what is happening. The gulf, the chasm between the expectation and the delivery.
And coming back to this judiciary in Sri Lanka, then now there is a growing satisfaction within the judiciary community that the way the promotions are given, they themselves have privately revealed this, that the promotions are given to lower order than the higher order. I don't know, you are aware of it?
Yeah, I'm aware.
I mean, why is it happening and how do you see that?
Well, I mean, many of these district judges and others have been students of mine in the faculty of law. There is a sense of dissatisfaction, that is true. That is because of the, you see, if seniority is disregarded, and people who are very much junior are appointed over your head, then there is a sense of grievance. Of course, the argument is that seniority is not the only criterion. That is true. And merit has to be considered. But then you have to define merit. It can't be entirely open-ended. How do you assess? How do you evaluate merit? What are the criteria? And if there is absolutely no attempt to define what you mean by merit, then the process has the appearance of arbitrariness. It appears to be arbitrary. That is the problem there, right? So, if I'm a senior judge, if I'm overlooked, and somebody very much junior to me is appointed, then I must know the reason for it. And it must be a justifiable reason. The person has been lazy, has not written judgments, it has been incompetent, or has been guilty of some wrongdoing, dishonesty. If those considerations are there, then certainly they will override the criterion of seniority. Seniority is by no means an absolute criterion. But there must be greater clarity. Then the other consideration is that there definitely is a role for Parliament, because under Sri Lanka's constitution, unlike in most other constitutions, judicial power is not directly vested in the courts. Under Article 4C, judicial power is vested in Parliament but is exercised by Parliament through courts and tribunals established by laws. That is, the judicial power is in Parliament. It is exercised through courts, right? Except in matters relating to parliamentary privilege where Parliament exercises judicial power directly. So Parliament has a right to go into these matters.
But I think when an opposition member raised this, the Speaker refused to take this, right?
Yes. So with all respect, I disagree with the Speaker. I mean, in a free society, one can comment. That is not disrespect, but there must be room for the expression of different points of view. As a professor of law, my firm and honest conviction is that the Judicial Service Commission does not exercise judicial power. You see, the Judicial Service Commission is presided over by the Chief Justice. There are other judges of the Supreme Court. So they are judges. That does not mean that they exercise judicial powers. There are many situations where judges exercise administrative powers. Right? So the Supreme Court exercises judicial powers. Judicial Service Commission does not exercise judicial powers. It is concerned with administrative matters, promotions, transfers, disciplinary control of judges in lower courts and so on. It's an administrative function. Right? So simply because you see a judge sitting there in the Judicial Service Commission, that does not mean that they are performing judicial functions. Right? So, and all of it, the Judicial Service Commission, its decisions with regard to the promotion, the transfer of judges, there should be oversight by Parliament. That is one of the pillars of our system. Parliament consists of the elected representatives of the people. They have every right to consider these matters. Right? Otherwise, you are shutting Parliament off from one of the vital areas of public policy, which are of immediate and intense interest to the community, the administration of justice. In any community where there are problems of different kinds in any society. But at the bare minimum, there must be the feeling on the part of every member of society, rich or poor, powerful or not, well-connected or not, that you can go to the courts and get justice. That is absolutely basic. It is indispensable. That feeling must be there. If it is not there, then there is a fundamental malaise. Right? So for that reason, Parliament has a role in these matters. And to say, no, Parliament can't discuss it. Right? Judicial functions, yes, it's wrong in Parliament to debate a pending case. That's wrong. Right? So there are standing orders, there are other principles. Because the judges are exercising their judicial minds in a case where evidence is being laid before them. That's a judicial function that is being exercised. But when the Judicial Service Commission is deciding whether to take some disciplinary action against Judge X or Judge Y, that is not a judicial function. That's an administrative function. And that has been recognized in some cases also. So there is not. So anyway, apart from authority in terms of principle, definitely the Parliament has a role. What is the proper policy with regard to the promotion of judges? Okay. Then other aspects, now take fundamental rights. Parliament has a role to consider what are the improvements that need to be made. To my mind, one of the current deficiencies is that the Supreme Court has sole jurisdiction. You see, in our system, if a matter relating to infringement of the Constitution finally comes out, a lower court, even the Court of Appeal, will have to stop proceedings. So Supreme Court has sole jurisdiction. But then, in practice, a villager in Dahiyatakandi, he has to come all the way to the Supreme Court. Evidence is only by affidavits. It is expensive. It is time-consuming. You have to retain lawyers in Colombo. So, in theory, those rights are there. But can they be actually enjoyed on the ground by ordinary people, by the vast mass of society? Will they have access? So those have to change. Maybe fundamental rights. There should be a system where these can be addressed in closer to the residence of the person having a grievance. Everywhere, right? Then there has to be greater provision of legal aid. What's the use of having a right? In theory, if you don't have the economic resources to make use of that right, that breeds contempt for the system. There's cynicism, so we have to change that. But all these are matters which should be open to public debate. That's the whole point. Parliament, not only Parliament must debate it, or ordinary society must debate it. Recently, I gave a guest lecture in the Faculty of Law. And I told them that, one of the functions of the law teachers is to make critical comments about judgments. You shouldn't be afraid to do that. I mean, in other countries, take the Cambridge Law Journal. In the United Kingdom, judgments in the House of Lords are sometimes torn to smithereens. I'm not suggesting that in Sri Lanka. Our culture is different. We shouldn't do that. But with proper respect, right? Differentially. Temperate language, certainly judgments of the highest court should be commented on in journals that are published by faculties of universities. That is one of the functions of a university, not just to provide instruction to full-time students. So all of it has to do with the public vigilance. Harold Lasky said, eternal vigilance is the price of freedom. Eternal vigilance. You are free, you can retain your freedom only if you're eternally vigilant. If you're thinking about these issues, you're commenting on these issues. Not if you're passive, supine, inactive. In such a society, freedom will disappear sooner or later. Right? So, in matters like this, there must be interest on the part of the community, and we must do everything possible. Now, you're certainly making a useful contribution in that regard to encourage people to be engaged, interested, express their views, not be inhibited, not to be scared. Many people think that criticizing a judgment of the Supreme Court is a contempt of court and that you will go to jail. That's not true at all. Lord Denning said justice is not a cloistered virtue. One of the basic principles relating to the administration of justice is that justice has to be administered in the open. You or I have every right to walk into any court anywhere in the country and to sit there and to listen to proceedings in that court. That is a basic right we have, except in very rare situations, where family matters are being discussed or confidential matters relating to a company or something. Then at the discretion of the judge, you can have a closed hearing. Otherwise, the openness of the administration of justice, and that is, it underlines the reality that you can have a system which serves the public only so long as the public are interested and constantly having an eye on what is going on and reacting as they should.
Professor, now what does this dissatisfaction among these senior journalists, senior judiciary officials who are not promoted and they were overlooked in the place of their juniors, what does this dissatisfaction mean?
Well, as he said, it means that I think what is required is greater openness, greater clarity with regard to the criteria for promotions, but then other things also now, the role of the Attorney General. Okay? Now that is giving rise to a lot of controversy nowadays. You can't take the view that the Attorney General's job is simply to file action. And that it is for the courts later on down the line, maybe in 2 years' time, 5 years' time, to decide whether the case is well-founded or not. That's not the case. The Attorney General has a duty to satisfy himself in terms of his own conscience that there is a prima facie case. And the phrase used is that is a quasi-judicial function. You see, he has to decide whether the evidence is sufficient, whether the probative value of that evidence warrants the institution of proceedings. Is it justified or not? It can't be done mechanically. And saying leave it to the courts to say, we just file action, let the courts decide. That's not the situation at all. The Attorney General has an independent discretion to exercise in the matter. He must disregard all other considerations, political considerations, is a person of influence and so on. All of that has to be put on a side. And he has to decide. And that is a non-delegable function. It's his right alone. His right, his duty. Right? So then, and no pressure must be exerted on the Attorney General. That would be wrong. I mean, there are so many instances in the history of our country. Dr. Maki Ratwatta, who was Mrs. Bandaranaike's private secretary, there was an allegation brought against him. The Attorney General, a very distinguished man, Mr. Victor Tenapon, QC, said, I can't prosecute. I can't. There's no evidence. I'm not satisfied. The then government, Mr. Victor Tenapon was promoted and they brought in someone from outside. And that Attorney General, Mr. Amir, he prosecuted. The court threw it out even without calling on the defense. So, it is very important to avoid the politicization of the office of Attorney General. The Attorney General has to make independent decisions with regard to matters that have a direct bearing on the quality of the administration of justice. So, these are some of the situations that are arising. Right? And the public need to know. There's one suggestion that the post of the Director of Public Prosecutions should be, it's not a new post, we had it earlier. Mr. Ranjita Surya, President's Counsel, was a DPP at that time. Is it a good thing? The argument is that there is a conflict of duties in the Attorney General. See, when you file a fundamental rights action against a president or members of the cabinet, it is the Attorney General who defends them. The Attorney General appears on their behalf. At the same time, it is the Attorney General who decides whether there is sufficient evidence to warrant a criminal prosecution. Are these two roles compatible? Is there a contradiction between them? So, people who have argued that there is a contradiction have said that it is much more satisfactory to entrust this prosecutorial function to another official other than the Attorney General, as a Director of Public Prosecution. Right? Other countries have had it. But is that a total solution to the problem? Then you have to ensure that the DPP does not come under political pressure. Right? The Attorney General, that's a large department. And we have had resolutions recently by all the members of the Attorney General's department saying we have confidence in AG, we'll protect him, we will not allow any encroachment and so on. No? So, then will it be easier or more difficult to exert political pressure on the DPP? Right? So that the whole suggestion with regard to a DPP has to be seriously considered, but I don't think that is a complete and total solution to the kinds of problems.
But isn't this why this government in their manifesto said they will bring in independent prosecutor's office?
But then, no, what I'm asking is, does the mere fact that you appoint a DPP give a guarantee that decisions will be made independently? The answer is no. So these are all matters which require lively interest on the part of the public. That is a fundamental point I've made.
This government, the first and foremost promise of this government was to eliminate corruption. And we see some strong activities from the Bribery Commission and then judiciary as well on in terms of corruption. How do you see that? I mean, are they actually doing something different from the previous governments? Are they actually doing it in genuine way? How do you see this?
No, there is no denying that there was a very strong interest on the part of the public to ensure strong deterrent action against people who were thought to be corrupt. And that is one of the reasons why this government swept into power. It's such a landslide. So they were expected to take drastic action, which they have done. Right? But then there has to be a sense of balance. Certainly, prosecute corrupt people. No question about it. Right? But you have to ensure that when you prosecute people, there is also, now say, very senior bureaucrats, senior government officials, right? When you put them in prison, when they are remanded, it does have a chilling effect on others in the public service, right? It is not every wrongful exercise of discretion that is criminal. Right, let's say take the Secretary of the Treasury or Secretary to the President or Secretary of Defense. If you make 25 decisions, some may be wrong. But corruption is dishonesty. There must be a dishonest motive, a dishonest intent. If there's a dishonest intent, then the rigor of the criminal law must be applied without any elasticity, right? But there's also, when it comes to investment, for instance, right, the wheels of government must turn. So public officials have to take responsibility, use discretion, right? But if they have this fear, we are only 2-3 years away from retirement, right? If we have criminal cases lodged against us, we don't have resources to defend ourselves, and we want to enjoy the evening of our lives with our grandchildren, relaxed, tranquil, not hanging around judges, lawyers' chambers and in the courts and so on. No? So that is the other side of the coin. I don't want to be misunderstood. I'm not saying that corrupt people should not be prosecuted. But when you have senior government officials, right, thrown into jail and sometimes long afterwards found to be completely innocent. At the stage you're remanded, you're still innocent or no court has found you guilty. So you're entitled to the presumption of innocence, and according to Sri Lanka's constitution, that is part and parcel of Sri Lanka's constitution. The presumption of innocence is part of our highest law, right? So you're thrown into jail, you're in remand, nobody has found you guilty, right? That is further down the road. So you have to be conscious of these other implications and nuances. But by all means, there have been some terrible cases, of course, right, involving the deaths of people, blindness, various. So those, certainly the public demands strong action and they're entitled to do that. And there must be strong action. It is a duty of a government. But this must be, that's not the only thing that a government must do. These are high profile things. Very important people thrown into jail. It hits the headlines. It dominates the evening news on all TV channels, right? So nobody can complain about guilty people being punished. But then government is elected to do other things also to make life easier for the people. So those must happen in parallel with this. This can't be the main focus. While it has to happen, there's a justifiable public demand for it. But other things, to make living, the cost of living, access to essential commodities, electricity, gas, right? The small and medium sector, education, all of this, availability of medicines at affordable prices. These are all things that are very much a part of the responsibility of government. So those must, you can't have the focus, the spotlight only on this to the exclusion of others. And because as time goes on, people will ask, what about these things? What about the quality of my child's midday meal? Is it getting better? So while corruption must be very severely punished, other functions of a government in power must also not be neglected.
Professor, this is the last question. I'm going to end where I started on legislation. Now, we, Sri Lanka, are recovering from economic crisis, and we need more investments, we need more enterprises, we need more businesses into Sri Lanka. Now, what does this U-turn in legislations and then dissatisfaction among judiciary, what does this means for the economic recovery?
So economic recovery means action in coordination by all these people. Right? We are today in a situation where the economy has stabilized. But I think in all fairness, you have to give credit to Mr. Ranil Wickremesinghe. It was a very difficult situation, and basically nobody wanted to touch it. But he had the courage. So even people who disagree with Mr. Wickremesinghe concede, sometimes grudgingly, that he did play a major role in putting the economy back on the rails. So now, and you see, the proof of it is that the present government is doing exactly what Mr. Wickremesinghe did. Not one iota of difference. The IMF agreement, the implementation of that agreement, right? If Ranil Wickremesinghe was in power today, the economic policy would have been exactly what it is now. There is absolutely no difference. Right? But that is stabilization. Stabilization alone is not sufficient. As we begin repaying our loans and so on, we need growth. Without growth, mere stabilization will not enable us to perform our obligations. Right? So for growth, you need investment. Now, investment is not sufficient. The investment that we are receiving into the country is not enough. There must be more investment. To have more investment, you have to have greater involvement on the part of the bureaucracy also. The officials have to be involved. See, the minister can say, this is a good proposal, we like it, we want it implemented. After that, it is the officials who have to take the ball and run with it. So if for whatever reason, the officials are half-hearted or inhibited, or not very engaged in what they are supposed to do, then the wheels will not turn as rapidly as they should. And that will have an impact on growth. So you have to enthuse everybody, bring them in. That's what we started with when we were talking about legislation. You see, it can't be insular, it can't be myopic, you can't work in a very restricted environment. People must come in, open the doors, let there be fresh air, breeze, blowing through the entire system. So they must all feel that they are stakeholders, that their advice is listened to, not necessarily accepted. Right? So then they are all active players, not passive onlookers. I think that is what we require at this moment to stimulate the economy in order to take the country out of the woods.
Professor Peiris, thank you very much for your insight and in-depth answers.
Thank you. Thank you very much.
Thank you, viewers, for watching this. We will come with the next episode. Until then, bye-bye.